In a unanimous 9-0 decision that has reverberated through the halls of the constitutional law and the firearms community in Washington, D.C., the United States Supreme Court ruled in favor of Smith & Wesson and other American gun manufacturers in Smith & Wesson Brands Incorporated versus United Mexican States. Yes, Mexico sued United States gun makers to bluntly put them out of business. This landmark case, decided in 2025, pitted the Mexican government against U.S. firearm companies in a legal battle over responsibility for cartel violence south of the border. For those who cherish the Second Amendment, this ruling is more than just a win for gun makers. It's a powerful affirmation of the rights of law-abiding Americans and the limits of liability in a free society. We're going to take you quickly, briefly, and in plain English inside the courtroom to what you need to know and what pro AR-15 legal gem just dropped in this case. Be sure to stick around to the end, where I'm going to be quoting an anti-gun judge who may have just saved AR-15s for the future. Guys, let's get into it. So really quickly, the story begins with Mexico's bold legal move, a $10 billion, that's billion with a B, dollar lawsuit filed against several U.S. gun manufacturers, including Smith & Wesson. Mexico claimed that these companies were fueling the brutal violence of drug cartels by designing and marketing firearms in ways that made them easily accessible to criminals. The complaint pointed fingers to the so-called military-style weapons like AR-15s and AK-47s, arguing that their design and aggressive marketing contributed to public nuisance and negligence that spilled over into Mexico's streets. They even highlighted guns with Spanish language names or graphics tied to Mexican history and insinuated and argued that these were deliberately crafted to appeal to cartel members. But the Supreme Court saw it differently. In a 9-0 decision, the justices shut down Mexico's claims, leaning on a key piece of U.S. law, the Protection of Lawful Commerce in Arms Act, or the PLCAA. We've covered this any number of times before and how important it is to the Second Amendment. This ruling didn't just protect Smith & Wesson and other firearm manufacturers. It sent a clear message about where the line is drawn between manufacturer responsibility and criminal misuse. One that might, and I assure you, will be used to protect manufacturers, retailers, distributors down the line to help protect and save the Second Amendment. So to understand this case, you need to quickly understand the PLCAA, the Protection of Lawful Commerce in Arms Act. This was passed in 2005. This was a federal law from DC, and it's like a legal force field for gun manufacturers and dealers. And by the way, other industries have this too. This is not unique to the firearms industry at all. This is just our version of it here. It says that they meaning distributors, manufacturers, and so forth, cannot be sued for the criminal actions of people who misuse their products. Think of it this way. If someone uses a kitchen knife to commit a crime, you don't sue the knife maker. The PLCAA applies basically the exact same logic to firearms. The idea is to stop lawsuits that try to pin blame on companies for the independent actions of criminals. Lawsuits that had been weaponized against gun manufacturers, again, that we've covered the lawfare against the Second Amendment industry. Also take a look at rare breed FRT, where it's at right now. But we've got multiple videos going into this into the 90s and about how the government could lose every single lawsuit and still bankrupt manufacturers. They could still bankrupt the Second Amendment. That's where the PLCAA came in. Now, there are exceptions, though. If a manufacturer knowingly breaks the law, like selling guns illegally, or if a firearm is defective, normal product liability applies. The PLCAA shield doesn't kick in then. Mexico tried to argue that their case fit one of these exceptions by claiming that Smith & Wesson and other gun manufacturers marketed and designed choices that basically crossed the line. The Supreme Court, however, wasn't convinced. Writing for the court, and again, a 9-0 unanimous decision, Justice Elena Kagan, an anti-gun judge from the left side of the court, said that Mexico's allegations didn't hold up under the PLCAA's protections. So, in Justice Kagan's opinion, she laid out a straightforward case. Mexico's lawsuit doesn't plausibly show that the Smith & Wesson or other manufacturers, and there were a bunch of other manufacturers that were sued here. We're talking about Barrett Firearms Manufacturing Incorporated, the guys, of course, who make those beautiful 50 caliber machine guns. We're talking about Beretta USA. We're talking about Glock. We're talking about Ruger. We're talking about Century International Arms. So we're talking about Century Arms. We're talking about Colt Manufacturing. whether or not they did anything to lose this shield of the PLCAA's protection. The court ruled that these companies couldn't be held liable for how cartels use their guns. That seems really common sense. It was a clean sweep. As I mentioned, 9-0 victory that underscored the strength of the PLCAA, and it is very much going to be defended by the anti-gun liberal side of the court. This is the part you stayed for, and this is good. For the Second Amendment supporters, which I hope is most, if not all of you, this was a big deal. The ruling didn't just protect gun makers. It reinforced the principles of law-abiding businesses shouldn't be punished for the actions of criminals. But it did one more thing as well. One of the most striking parts of this decision came when Justice Kagan tackled Mexico's focus on so-called military-style firearms. Mexico zeroed in on weapons like the AR-15 and AK-47, among others, arguing that their design and marketing made them cartel favorites. But Justice Kagan pushed back with a reality check that's music to the ears of gun owners and Second Amendment supporters. Here's what she wrote in part, quote, "Finally, Mexico's allegations about the manufacturer's design and marketing decisions add nothing of consequence. As noted above, Mexico here focuses on the manufacturer's production of military-style assault weapons, among which it includes AR-15 rifles, AK-47 rifles, and .50 caliber sniper rifles. But those products are both widely legal and bought by many ordinary consumers. The AR-15 is the most popular rifle in the country," in reference to the United States. Please excuse this brief interruption to support our sponsor. Our sponsor today is my law firm. We've got over 50 employees, over 30 attorneys, all over the state of Wisconsin. We are here in the state of Wisconsin. We handle criminal defense, divorce, and we also have estate planning. Different wings of the firm do different things to make sure that you always get the best attorney at a price point that you can afford. And if you're enjoying this and other educational legal content that I've done, well, thank you for joining me, number one. But number two, please consider dropping a 5-star review. You can find posts down that will be linked to different Google platforms. You can check out some of the details below. I appreciate you sticking around. Don't miss the quote of the day at the end of the video. Now back to the show. This isn't just about legal jargon. It's a bombshell for gun rights. She doesn't only point out, she acknowledges, she admits that AR-15s are not some sort of exotic weapon of war. It's the most popular rifle in the United States, which they are, owned by tens of millions of Americans, for self-defense, hunting, sport shooting, all lawful purposes. The same goes for AK-47s and all sorts of other similar semi-automatic centerfire rifles. Sure, cartels might like them, but that doesn't mean that manufacturers are to blame. If cartels like Corvettes, are we going to blame GM, Chevrolet? Are we going to ban Corvettes? If they start using Corvettes to run over people, are we going to start banning the manufacturer of Corvettes? It's the same logic. Why is this important? This ties directly back into the super important question of, are AR-15s and AK-47s protected by the Second Amendment? Anti-gunners say no. People with half a brain say yes. The answer hinges on a concept from the 2008 Supreme Court case, District of Columbia versus Heller, later reinforced by the Supreme Court in 2016 Catano, and of course the Brune decision in 2022, where the Supreme Court said that the Second Amendment covers firearms that are in common use for lawful purposes. Kagan's words here are not only a nod to that idea, it's an alley-oop slam dunk of that idea. If the AR-15 is the best-selling rifle in the country, now acknowledged by an anti-gun justice in a Second Amendment decision, owned by law-abiding citizens in droves, it's going to be hard to argue that it's not in common use when the anti-gunners come for it, which is every day, but AR-15s will have their day soon before the United States Supreme Court. That makes it a tough target for bans or restrictions, something that gun control advocates are going to have to wrestle with. So this case isn't about banning guns outright. Like most Second Amendment cases, it's usually not a direct attack like that. Sometimes it is, but this is one of those sideways attacks. But Justice Kagan's words, reasoning, which I now call evidence, gives us a peek into the court's thinking. By highlighting the AR-15's popularity and lawful use, she's laying groundwork that will shape future battles over these so-called assault weapons, in other words, modern sporting rifles. If these firearms are indeed in common use, which they clearly are, and she, as well as Previously, Justice Sotomayor, her close colleague and ally on the court, both acknowledge and admit now, then any attempt to outlaw them will face a very steep constitutional hill. Again, it's not a direct ruling on bans. Obviously, this case wasn't about that. This is digging those trenches and building those bunkers for when we fight those battles down the road. So for pro-gun folks, this case is a double victory. The PLCAA stays intact, shielding the industry from, bluntly, frivolous lawsuits that are designed to cripple and destroy it. And the court's language bolsters the case for keeping AR-15s and similar rifles in civilian hands. It's a reminder that the Second Amendment isn't just about hunting ducks and shotguns. In fact, it really isn't about that at all. It's about the tools for American liberty. So if you've made it this far, congratulations. We're going to close out with our ever popular quote of the day. Let me know what you think about this. Will these bunkers, will these trenches stand or fall when we go back to the Supreme Court? Let me know if you want me to do a video where I analyze both Justice Kagan and Justice Sotomayor's quotes and how this could all play together. Let me know down in the comment section down below. We're going to close out with a quote of the day from Rory Miller, who said, quote, "The only defense against evil, violent people is good people who are more skilled at violence." Absolutely. That's a realist take on the world. And I look forward to seeing your takes on this video down in the comment field below. Be sure to hit that like button, and I'll see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.